Fundamentally, a contract is an agreement. A contract does not exist and neither party has obligations under the contract unless the parties have reached a state of agreement. In the best case scenario, this is accomplished by having both parties sign a written agreement. However, this is far from the only way for agreement to be established. This case takes place in the early 1870s, a time of great industrial turmoil in the United Kingdom. Rail was king of transport, moving passengers and goods at unprecedented speed all around the country. However, the trains relied on coal, and coal relied on coal miners. Coal mining at this time was incredibly dangerous work, and the rate of fatalities had begun to lead to industrial action, including strikes. Railway companies, such as the Metropolitan Railway Company then, were desperate to ensure they had reliable supplies of coal. They had for some time been receiving coal from Brogden and Company, a colliery in Wales. By 1871, Brogden suggested they formalise their commercial relationship with an actual contract. They entered into negotiations and Metropolitan Railways agents drew up a draft contract for the supply of between 220 and 350 tonnes of coal each week for 1 year. Brogden examined the contract, made a few minor changes and wrote "approved" at the bottom. The draft was then sent back to Metropolitan Railway, where the relevant officer put it in a drawer and forgot about it. The parties then carried on as though the contract were in place. When Brogden found it difficult to meet the requested amounts, they discussed their positions with reference to the contract. When the commercial relationship broke down, Metropolitan Railway sued for breach of contract, and Brogden's responded that there was no contract because there had never been agreement to their amendments, and Metropolitan had never signed the contract at all. The House of Lords found that there was a contract. The Lord Chancellor, Lord Cairns, said there was clearly a consensus between these parties. Metropolitan Railway's approbation or approval was clearly given when the company commenced a course of dealing which is referable in my mind only to the contract, and when that course of dealing was accepted and acted upon by Brogden in the supply of coals. From this case we learn that agreement to a contract can be inferred from the conduct of the parties.